Finally, however, we have to note that the litigation of employment discrimination suits differs from normal lawsuits. The law requires that a discrimination plaintiff go through an administrative procedure before filing a lawsuit. And what that means is the employee plaintiff, the plaintiff bringing a discrimination claim, must file a charge of discrimination with an appropriate agency before filing the suit. Now, that appropriate agency is often the Equal Employment Opportunity Commission, the EEOC, which oversees a number of statutes having to do with discrimination. And what this rule requires is that an employee with a cause of action must file a charge with the EEOC prior to filing the lawsuit. This is unusual in the law. Ordinarily, with any other type of dispute, a tort case or a contract case, you simply file your lawsuit. But with discrimination cases, you have to go through this initial administrative procedure. And we do that by filing a charge with the EEOC. Now, there is a very short statute of limitations, a period of time in which to file your charge. In employment discrimination cases, the employee plaintiff has only 180 days to file a charge with the EEOC. Only 180 days. 6 months from the date of the discrimination to the date of the charge. And this puts a burden on employees, and I always tell students that if you believe you have been discriminated against, you must act quickly. You've got 6 months in which to file a charge, and if you wait more than that time, then you're unable to bring that claim. You've lost your ability to bring that claim. Now, this is tempered somewhat by state law. Every state has its own discrimination statute based on Title VII, but sometimes expanding protections. It may have a ban, for instance, based on marriage discrimination or sexual orientation discrimination. So states have their own statutes. And every state has an administrative agency that does the same thing as the EEOC. Those state agencies are called Fair Employment Practices Agencies, or FEPA. An FEPA is simply the state agency that does the same thing as the federal EEOC, meaning they are going to administer employment discrimination claims. Now, because of this dual nature, the law has constructed what we call the ability to dual file, which says that an employee may file his claim, which is called a charge, with either the state FEPA or the EEOC. It doesn't matter whether your claim involves an employer who lives in your state or not. You have the option as an employee to file with either office. Why would you choose one over the other? Well, there may be a quicker turnaround with the state employment agency, or you may feel like the federal agency is going to be more fair if you work in an industry that, for instance, that's tied to the state. Nevertheless, the power is yours, and you can file that claim with either the state FEPA or the EEOC. And it's just as if you filed it with both offices. Now, one of the benefits of filing with a state FEPA is that some states allow for an expanded statute of limitations, meaning you may have up to 300 days in which to file your claim. It's not every state. No state has a shorter one than 180 days. Some states, however, allow you to go up to 300 days, so essentially 10 months as opposed to 6 months. Now, the charge is meant to include specific information the employee's name, the employer's name, where it happened, what happened. Precise factual allegations are what should be found in the charge. And once the agency has the charge, then they have a process that will go into effect. Ordinarily, the first thing either agency does, either EEOC or state FEPA, will send the case immediately to mediation to allow the parties to talk it out. If the parties can resolve the case at mediation, then the agency has no more work to do with this case. And so the agency will usually send it to mediation immediately, just in case that the parties are able to resolve it by talking to one another. The agency, if doesn't settle at mediation, the agency then investigates the claim, and that investigation can take as little as 6 months. It can take as long as 2 years. There is a process involved. There's a time-intensive process whereby the agency interviews the employer, interviews the employee, may collect evidence. The agency is going to conduct an investigation of the claim. After having investigated, the agency can do one of two things. The agency may simply choose to litigate the suit itself in federal court, meaning the EEOC will bring the claim in federal court, will bring a claim on behalf of the employee. Now, this is pretty rare. Maybe 3% of claims are actually brought by the EEOC. When it does occur, it usually indicates that the EEOC believes this is a problem not just for this particular employee, but a number of employees in the same field, working for the same company, or that are employees in the same industry. So the agency may choose to litigate the suit itself, or it may issue what's called a notice of right to sue, a right to sue letter. And what this is a letter to the plaintiff, to the employee, that says, we are not going to file a lawsuit on your behalf. You may, however, choose to file that lawsuit. So the agency issues this letter, the notice of right to sue, which then starts another clock running. Once the employee receives the right to sue letter, what we call the right to sue letter, the employee has 90 days to file her suit before it expires. If you wait longer than the 90 days, your claim may expire. So in conclusion, employment disputes can be resolved in state or federal court. Trial courts decide facts, appellate courts decide questions of law, and the litigation of employment discrimination litigation differs from normal lawsuits. And that's it. Thanks.